have one final case on the docket this morning, case number 16-3763, Terry Trussell versus the state of Florida.
May it please the court, I'm Arthur Moorberger. I have my co-counsel with me, Inger Garcia. I'd like to reserve 5 minutes for rebuttal.
Thank you. 5 minutes.
Yes. And this is a case in which I represent Terry Trussell. Terry Trussell is sentenced to about 9 years in jail for violation of section 843.0855. Now this statute, it's important to note, in section 5B includes a provision that this section does not prohibit individuals from assembling freely to express opinions or designate group affiliation or association. Well, that's exactly what the true bill that he was charged with having filed did. Looking at State's Exhibit number 1, which is at page 10146 of the record, that charged Mark Raines, the superintendent of schools, with criminal conspiracy to implement Common Core standards, initially caused harm to the minds of the children of Dixie County, Florida, initially depriving the parents of the children in Dixie County, Florida, their rights to control the standards of education for their children. And it's signed by Terry Trussell as foreman, People's Grand Jury under common law in Dixie County, Florida.
Mr. Moorberger, if I could ask you a question. It's actually related to issue 5
Yes.
of your initial brief, and let me just read as that's captured in the brief. It says the prosecutor committed fundamental error in including in his closing argument a false contention that certain uncharged conduct was charged. So we understand the false contention was that your client had misrepresented the reason for getting the courtroom, and then the uncharged conduct was that was not part of the information. And so based on the Brown versus State case, it would be the position of your client that that would be fundamental error and we would reverse on that basis alone. Did I understand that rightly?
That is absolutely correct.
And the purported or alleged falsity of the comment is predicated upon the concession by the clerk, Ms. Johnson, in her cross-examination, that on reflection, it was her recollection that Mr. Trussell did not represent to her that he needed the courtroom because of some grand jury official business. Is that correct?
Well, there's one further caveat, and that is that if the court looks at page 32 of the answer brief, there is a concession in the answer brief that that was not an element of the crime charged. So the prosecutor charged 2 elements. He said this was a 2-element crime, and that was the first element, and we contend that that was fundamental error.
What do you do, Mr. Moorberger, with the argument, and I don't know that they addressed it directly, implicitly they said that information was relevant because it was all part of this overall scheme. What would be your response to that?
Well, I would contend that the jury was certainly misled by what the prosecutor said, and though it may have possibly had some relevance, the relevance was only to be taken into account with the fact that Mr. Trussell did not file the true bills as being done by the grand jury foreman. It was being done by the people's representative on the common law of Dixie County. So it wasn't really anything simulated. It wasn't a simulated process at all. And that's our contention. It was not a simulated process. Obviously, this is all First Amendment activity. First Amendment activity needs to be clearly proscribed by a criminal statute. And there was nothing in that statute that proscribed that activity. This was not simulated process because the process was never filed. The process was submitted to the court clerk, Ms. Johnson, with an understanding that it would not be filed in the official record. Johnson specifically admitted that at 138 of the transcript, 137 and 138 of the transcript. She admitted that there was an understanding between her and Mr. Trussell that would not be filed, that nothing that he would submit to her would be filed. So therefore, it was not simulated. And
Mr. Moorberger, in issue 6, you make the argument, raise the contention that the trial judge abused his discretion by dictating defense strategy, that is, by not allowing you to call the clerk during your case. The state's retort to that is, well, there was never a request to have the clerk back on at the end, which the court had given you that potential option when he made his decision not to allow you to call the clerk during your case. How do you respond to that, meaning the state's response to your argument?
Well, of course, the court will note that in my reply brief, I did not respond to that argument. And I felt that there were other arguments that were stronger than that argument, since they pointed out case law to the effect that the judge has control over the court process. And that's true. The court does have control over the court process. But this is a criminal case. This was an extreme situation. This was a situation in which one of the witnesses was going to be sitting up with the judge as a court official. And of course, we were unable to find any cases anywhere in the United States that involve this issue. It was just, apparently it's never come up before in the American courts. And so I would be asking the court to make its own decision, an initial decision on this issue, that this cannot be done.
Trial counsel, as I recollect, made the objection related to the clerk sitting next to the court, that counsel had a concern, maybe even a slight concern, but I don't remember a motion for mistrial or a request that she, meaning the clerk, be removed from the courtroom. Wouldn't you agree that something like that would need to happen for us to be able to address that, or not?
That's why that didn't go into the reply brief. And that's true. That's true. The counsel apparently was so taken aback by this conduct that she didn't really file a motion. And I noted that, and that's true. But we have other grounds, and the other grounds are that we have this subsection 5B of the statute, which applies. It applies to all activity to express opinions. And that's exactly what Mr. Trussell was doing. And as a matter of fact, when the case went to the jury, the judge instructed the jury with regard to Section 5B of the statute, but only with regard to count 1. In other words, the judge did not instruct the jury that 5B applies to count 1, 2, 3, 4, and 5. And that's where the jury found Mr. Trussell guilty. Now, the jury, in other words, was misled to think that it only applied to count one. There was indeed a very clear motion and argument on the part of defense counsel that that was not done. Counsel objected to the jury instructions and pointed out to the judge that count one was the only one that was addressed in the jury instruction. Now, with regard to count two and count one, that refers to subsection 2 of the statute.
Now, Mr. Moorberger, you're into your rebuttal time, so you may continue, but I just wanted you to be aware.
Okay. Well, the only other point is the point that I made in my reply brief, and that is that the subsection 2 refers to acts under color of law, and acts under color of law were not deliberately. The statute has a comma after deliberately in that statute, and there is nothing indicated that there has to be any form of mens rea or scienter in regard to that, and that would be, in my view, unconstitutional. I ask that the court reverse.
Thank you.
May it please the court, Tricia Max-Pate representing the state of Florida. I want to make it clear, in this case, he was not charged, and the state has never alleged that he was charged with assembling and meeting together to express opinions about Common Core education. What he was charged with was filing these indictments, these true bills, indicting numerous government officials with crimes, and he filed them in the clerk's office in the official record. That's what he was charged with. Now,
Counsel, let me ask you about that. You just said that he was charged with violating the true bills. I see an argument, in closing argument, by the prosecutor that says that Mr. Trussell should be found guilty based on his misrepresentation to Ms. Johnson about the reason he wanted the courtroom, and I don't see that in the information. So if he's charged with violating the true bills, that would suggest to me it's not in the information, and an argument's being made that he should be convicted of an uncharged crime, which would be a due process violation. Explain why that's not true.
I don't think that's what the prosecutor was saying. I think what you're saying is you have to look at the act in total, and he approached Ms. Johnson to get the courtroom that morning before the grand jury was to get there, because at that point he was done with the grand jury. He had already tried to present his claims about Common Core to the grand jury, and the grand jury had rejected that. So he met with her and either said outright, because her testimony kind of changes on that. At one point she says for the grand jury purposes to get the courtroom. On cross-examination, she says, well, he may not have said grand jury. On redirect, and I think that's page 39, she then kind of waffles if it was for the grand jury or to get the courtroom, or she thought it was for the grand jury because he was the grand jury foreman. But he meets in the courthouse before that, and then after which he files the true bills. I don't think meeting with his group of the People's Common Law Grand Jury is the crime, but it's very relevant to his actions that he's using this position as grand jury foreman to give the impersonation of a public official. I think it's kind of like it's not a crime to case a bank, and I think that's what the prosecutor was doing as an example.
I certainly understand, I think we all do, that it may be germane, may be relevant to the jury's consideration to have all of these other facts brought to their attention. The issue, as I understand it, from the defense is the jury is asked to convict him based on this uncharged crime. And I'm just looking at the rebuttal here. We have a transcript of the rebuttal. You should find the defendant guilty of counts 1 and 2 because he used a ruse to get the courtroom. So counsel's asking the jury to convict the defendant because he purportedly used this ruse to get the courtroom, which was ultimately denied by Ms. Johnson as I read her testimony on cross. But all of that aside, I just don't see that in the information. So what would you have us to do with that?
Well, one, the jury was instructed as to what they were to find for the charges by the trial judge. And the jury's also instructed that what counsel says is not evidence or not crime. It's not the charges. The jury instructions by the trial judge was the instructions as to what they were finding the defendant guilty of. What the prosecutor says is not the jury instructions. I think they're explaining that, but I think you have to look at it in total. And also, we're looking at it as to vitiate the entire trial because it was never objected to in the trial court.
Well, there was an objection after the statement I just read, which is somewhat interesting. It was a 404B objection by trial counsel. Now, there was not an objection that this was not charged, but thinking it through, looking down the timeline, 404, as you know, deals with character evidence, deals with unrelated bad acts, and not to get into the mind of the defense attorney, but it would suggest that she was saying to the trial judge, this was not something that this man is being charged with, so it's not relevant, it's not germane, it's prior bad act evidence. Assuming that objection was made, the 404B, and I looked at the transcript last night and it was, does that change the algorithm as far as the fundamental error analysis or not?
Well, no, because it would have been very nice if they'd admitted the objection you just did and explained the trial court exactly what they wanted. If that was the concern that it's misleading the jury, then a curative instruction would have been very helpful. There's numerous ways to cure that rather than waiting to argue that on appeal. And that's the problem here. It wasn't a 404B issue. If you wanted a curative instruction, if you wanted to make sure that the jury was clear as to what was the charges and what wasn't, then to ask for that would have been very helpful. But now we're up on appeal. The time to cure that error was then, especially when they made the objection. If they'd have clearly made an objection to the court, maybe this could have been resolved, but they didn't ask for a mistrial then. They didn't ask for a curative instruction, and now they want to argue fundamental error on appeal, and that has to be so prejudicial to vitiate the entire trial. And again, you have to look at the trial in total as to what happened.
But another way to get to fundamental error would be asking the jury to convict the defendant of an uncharged crime based on the Brown case, Brown versus State, the 2010 4th DCA case. Wouldn't that be another way for them to make that same fundamental error argument based on the due process violation of asking the jury to convict him of something that was not included in the information?
It depends. Fundamental error is going to be an individual decision in every case. It's not something that may be fundamental error in one case may not be in another case. So I think you have to look at each case in total. So even though it may have been fundamental error in the Brown case, it doesn't necessarily mean that it's going to be that, because fundamental error is an individual decision. It's not a per se reversible decision. I think it has to be very clear that the defense has the burden to show that this vitiated the entire trial. So it may be a serious error, but it may or may not be fundamental error depending on the facts of each case. And I think in this case you have to look at what happened too, because it's unquestionable that he went back to the clerk and asked the clerk to file these documents, was going to pay for them to be in the official record. So if we're talking about the confusion of anything about the grand jury assembling together, they were also instructed that First Amendment activities are exempted from consideration. So I think they were thoroughly, properly instructed by the trial court. So we're talking about reversing a trial based upon a unobjected to error that could have easily been cured had it been properly objected to in the trial court, and you want to vitiate the entire trial. And they were properly instructed, and they were properly instructed that First Amendment activities are or are exempted from the statute.
There are different activities that underlie the conviction under subsection 2 of the statute and subsection 3. It seems like what I hear you telling me is that having the clerk of court stamp the true bill, file it, is the basis for impersonating a public officer relating to any process, and it's also the basis for simulating legal process.
Correct.
Are there elements that are different? in each-
Well, I think when you have to act as a public official to go in there, which I think he was acting as the grand jury foreman and going back there. And that's where I think all the testimony about getting the space, doing it in the courthouse right before the grand jury was to meet on the same day and bringing it back as the grand jury foreman. And that's where I think his letter writing comes in, writing her to, ignore the state attorney, dismissing the grand jury. All those things show his intent to use his position as grand jury foreman to ramrod these things through. So I think there's slight differences in the intent of the statute. Any First Amendment activity would be exempted. But again, I don't think we have any First Amendment activity here in filing these true bills against these elected officials. And that's the crime that was committed on both incidences. I mean, they're the same acts, but two different things. One is the grand jury foreman. He comes in to file these, impersonating the grand jury foreman to get her to file them. And the other is just filing the indictments itself, simulating legal process.
And you've used the term files the true bills. How are you defining that? Because there seems to be an issue here as to whether the clerk assumed that he wanted them filed or if he actually asked for them to be filed, and then she later, regardless of the answer to that first question, removes them from the public filing and puts them in a separate file. So I think that goes to the information using subsection 3, and I guess the second question would be, how do you define simulates in that context?
Okay, she testified, and I think it's on 238 of the record. It's the trial transcripts on the corner, the right-hand corner of it, that he came in and said he wished to have these filed in the official record. She glanced at them, she filed them. Later, she realized they were improper, and removed them from the record.
I thought on maybe it was on cross when they said, did he actually say, I want these filed? And she said, well, no, I just assumed. And then there was testimony as well that they had a previous understanding that, or an agreement that nothing is filed unless I say otherwise.
I think her agreement, what he was referring to, and it went back on forth on cross, it's a very convoluted record, but what she testified to is their agreement was that he told her, there was no agreement, he told her, do not accept anything from the state attorney or the chief judge. But I think she very clearly and succinctly said, he said, I wish to have these filed. He paid for them to be filed, so I don't think there's a question of whether he wanted them filed. He had them filed. And I think if you look at it at page 238, that is very clear in her direct testimony.
And how would you define simulates as it's used in subsection 3?
I think you would look to its common usage. It's common. You can look at a dictionary definition, and I think I quoted Webster's dictionary in my brief, and I have it somewhere in my notes, but I think you can just, it's plain and obvious meaning. It means to give or assume the appearance or the effect with the intent to deceive, is one of the, dictionary definitions, but you could just look to a dictionary definition. But legal process, is defined in the statute, and it's defined very thoroughly, meaning documents, orders issued by a court or filed or recorded within an official record of the state or the United States or with an official government entity. It's a very broad definition. It includes, but not limited to, summons, liens, complaints, warrants, injunctions, writs, notices, pleadings, subpoenas, or orders. So I think it's clearly defined, but simulating. So whether he actually filed it or, or simulated to try to file it. But I think in this case, it was clearly filed with the court. She later removed it because it's improper, but it was filed. Unless the court has any other questions, the state would ask that you affirm. Thank you very much.
Well, first of all, the state clearly agreed that there was only one element to the indictment, and that the element with regard to bringing the assembly together into the courtroom was not an element. And that is supportive of our claim of fundamental error. The prosecutor was a representative of the state, and the state misrepresented to the jury, and the jury was surely misled by that representation. And that was the intent of the prosecutor. It seems to me that that alone should require a reversal. Now, in addition to that, there should be a reversal, and Mr. Trussell should be acquitted entirely because of subsection 5B of the statute that exempts First Amendment activities where you're intending to express an opinion. And that's exactly what Mr. Trussell was trying to do. Now, Mr. Trussell had an agreement with the clerk that nothing that he submitted to the clerk would be filed. Now, I'm not talking about recording. Recording may require some money to be paid, but nothing was to be filed. And the clerk, in accordance with that agreement, removed those documents from the record, left the records with blank pages, and so nothing was left filed. Now, when we're talking about simulated process in subsection 3 and 4 of the statute, there was no simulated process. Process is something that has to be filed under the definitions of Florida statutes. They have to be filed. Now, what happened was that defense counsel asked the court to instruct the jury with regard to the definition of process, with the definition of filed, and the court refused to do that. What the court did was to submit to the jury a jury instruction that section 5B applied only as to count 1, not as to counts 2 and 3 and 4 and 5. So the jury was misrepresented. Now, getting back to the elements of a crime, this was not a crime because the records were not, there was no simulated process. It was a First Amendment activity. First Amendment activity must be explicitly set out in the statute so that there cannot be any chilling effect on the performance of First Amendment activities. And this statute did not warn Mr. Trussell that what he was doing was wrong. He didn't do it as the foreman of a grand jury. He did it as the foreman of a common law of Dixie County grand jury, people's grand jury, and it's clearly made it out that he was not representing any official organization.
Thank you, Mr. Morberger. Case is submitted. We'll be in recess.
All rise.